Welcome to BusinessTraining.com. The video module today focuses on the Worker Adjustment and Retraining Notification Act, or WARN Act. This is our agenda for the video topic today. Please take a moment to review the outline. The Worker Adjustment and Retraining Notification Act, or WARN Act, was enacted in 1988 and outlines the protection to covered workers by requiring a notice of at least 60 calendar days in advance of a qualified plant closing or mass layoff. The Act generally covers employers that have 100 or more full-time employees. It does not count employees who have worked less than 6 months, in the last 12 months, employees who work less than 20 hours per week. The Act includes salaried or hourly wage workers as well as managers and supervisors. What situations cause a notice to be triggered? The first trigger can be a plant closing, which is defined as an employment site or one of more facilities or operating units within that employment site, which will be shut down. The shutdown has to result in the employment loss of 50 or more employees during a 30-day period, not counting the non-covered employees who work less than 20 hours per week. The second trigger is if there is a mass layoff that results in the employment loss at a single site of employment during any 30-day period of 500 or more employees, or if 50 to 499 employees suffer an employment loss if they can make up at least 33% of an active workforce. The other trigger is if within a 90-day period, a series of related layoffs occur which will reach 500 or other employees, or 50 to 499 employees if they make up at least 33% of employees, unless the employer can demonstrate that the losses were due to separate and distinct actions or causes. Employment loss is defined as an employment termination that is other than a discharge for cause, voluntary departure, or retirement, and the termination of a 6-month period. If they meet these 3 criteria, the employee has suffered an employment loss. Employees are entitled to warn if the notification triggers are met and they fit the employment loss definition. Employees do not suffer an employment loss or are protected if they are considered to be a striker or worker who has been locked out in a labor dispute. Additionally, workers working on a temporary project or facility clearly understand their temporary nature of work when hired. Business partners, consultants, or contract employees who are assigned to a business but have an employment relationship with another employer and are paid by that employer or are self-employed. Regular, state, or federal government employees are not covered. Employees that are offered a job within a reasonable commuting distance, whether they take the job or not, or employees offered a job outside of reasonable commuting distance and have accepted the job within 30 days of the offer, or within 30 days of the plant's closing or mass layoff occurring, whichever comes later, are not considered to have suffered an employment loss. The 2 employee transfers discussed on the last slide must meet 2 conditions to meet the transfer rule. An offer of a transfer must be a direct result of a consolidation or transfer of the employer's business, and the offer must be made before the plant closing or mass layoff actually occurs. An offer of reassignment to a different site of employment does not make it a transfer if the new job constitutes a constructive discharge. A constructive discharge is when a worker's resignation or retirement may be found to be involuntary because the employer has created an intolerable or hostile work environment, or has applied some form of pressure or coercion that forced the employee to quit or resign. If this is the case, the employee is then covered under WARN. If employees will be terminated on different dates, the date of the first individual to be terminated within the 30-day or 90-day period triggers a 60-day advance notice requirement. In the event of a sale of the business covered, if the sale results in a plant closing or mass layoff, a 60-day notice is required. The seller is responsible of the notice if it fails within their responsibility, which is up to and including the date and time of sale. After that, the buyer is responsible. An employer does not need to give WARN notice if the plant closing is a temporary facility or if the closing or mass layoff is a result of completion of a particular project. This exemption is only applicable if the workers understood their limited employment depended on the duration of the facility or project upon hire. A project that is ongoing within the company cannot be labeled as temporary to avoid WARN notice. WARN notice must be timed to ensure they reach the required parties of at least 60 days in advance, with the exception of 3 circumstances. First is a faltering company exception, where the company is seeking new capital or business, such as a pending merger or business deal, in order to stay open, where giving such notice would ruin the opportunity to obtain the new capital or deal. This applies only to plant closings. The second exception is an unforeseeable business circumstance, such as the internet bubble burst, where giving advance notice would have been impossible. This applies to both plant closing and layoffs. Finally, the last exception is in natural disaster, such as an earthquake or flood, where a closing or layoff would not have been possible to be notified in advance. The employer must provide proof of the conditions of these exceptions being met and must give as much notice as possible. Employers must give notice to the chief elected official of the exclusive representative or bargaining agency or union of the affected employees and to unrepresented individual workers who are reasonably expected to experience an employment loss. This may include employees who lose employment due to bumping rights. Bumping rights provide for an employee to displace or bump another employee due to a layoff or other employment action as defined in a collective bargaining agreement, policy, or other agreement. These rights are often through a seniority system. Essentially, the more senior employees are less likely to get bumped or laid off. Incumbents in jobs that are being eliminated must also be notified, as well as employees who worked for less than 6 months in the last 12 months, or less than 20 hours per week are entitled to notice, though their numbers are not counted in determining notice triggers. Notice must also be sent to the state dislocated worker unit and to the chief elected official of the local government in which the employment site is located. No particular form of notice is required, but the notice must be in writing and delivered using a reasonable method of delivery. The notice must be specific and state points of the layoff or plant closing. It may be conditional, however, being dependent on the occurrence or non-occurrence of an event that dictating the tentative layoff or plant closing if it is less than 60 days after the occurring or non-occurring event. The notice must explain if the layoff or plant closing is permanent or temporary of 6 months or less. It must include the date of layoff or closing and date of separation or period of separation for employees and a name and contact information for a person in the company to go to for more information. Extensions of notice can be given if the planned layoff or plant closing is extended beyond the ending date of any period of separation given in the original notice, unless the extension is beyond 60 days. Then a new WARN notice is required. Employers who violate the WARN provisions set forth by ordering the closing of a plant or mass layoff is liable to each affected employee for an amount including back pay and benefits for the period of violation up to 60 days. The liability may be reduced if wages were paid to the employee by the employer during the period of violation. Employers who do not provide notice as required by the local government are subject to a civil penalty of up to $500 for each day of violation. This liability may be avoided if the liability is satisfied to each aggrieved employee within 3 weeks after the closing or layoff is ordered. Enforcement of the WARN Act is through the U.S. District Courts. Workers, representatives of workers, and local government officials may bring individual or class action suits to court against an offending employer. Where is the single site of employment if an employee travels a lot within a large area, for example, a salesperson? For workers whose duties require regular travel, the employee's single site of employment for WARN purposes is the location to which the worker is assigned as their home base or location from which workers are assigned duties, or the location to which they report. If an employee was on leave, such as medical or maternity leave, when notice was given to other workers, should they have received the notice as well? Yes. Any workers on leave who reasonably expect to have continued employment with the employer at the end of their leave are required to receive notification at the same time the other workers receive notification. If affected workers of a closing or layoff cannot be identified, should a blanket notice be given to all employees or possible affected employees? If an employer cannot identify who may reasonably be expected to be laid off at the required time of notice, the employer must then give notice to those workers whose jobs will be eliminated as a result of the plant closing or mass layoff. It is not appropriate to provide a blanket notice to all employees. If the buyer of a business continues to employ an employee but decreases their wages and benefits, has the buyer constructively discharged them? Yes. If a drastic change in wages or working conditions causes a person to believe that he or she was being fired or would be unable to continue working for the buyer, it may constitute a constructive discharge. Is an employer exempt from giving notice if it declares bankruptcy? WARN is still applicable to an employer that declares bankruptcy under some circumstances. There are two situations under which WARN still applies to the employer declaring bankruptcy. The first situation is when the employers know about a closing or layoff before filing for bankruptcy and is still required to give advance notice and cannot use bankruptcy to avoid giving notice. The second situation is when an employer continues to run the business in bankruptcy as a debtor or possession. If a closing or layoff is foreseen to occur after that, the employer is required to provide notice. The only exceptions are the three exceptions of faltering company, unforeseeable business circumstances, or natural disasters. Can an employee waive their rights to notice under WARN? An employee cannot be required to waive their right to advance notice. The employer that closes or has a layoff may ask employees to sign a document waiving their right to make claims against the employer, however. This is usually done by offering an additional severance pay or extended health benefits, and any right to claims can be waived if done so knowingly and voluntarily. If you would like more information on Worker Adjustment and Retraining Notification Act, please go to the Department of Labor website at the following link. Thank you once again for your time and attention, and this is businesstraining.com, where you can earn a master's level qualification to make more money.